It's really hard for me to tell you how glad I am to be here and be a part of this gathering. Now, I tend to read my notes. My father was a Methodist minister, and he typed out every sermon he ever used, word for word, and I tend to be sort of the same way. Don't worry, it's very big letters. It's not going to take all that long. My next sentence that I wrote, I kind of feel is not right. I said I'm not a member of the Ford family. But after being here for a couple of days, I feel sort of like I am, because your generosity and your welcoming me and your cordiality has been just superb. But I'm not a descendant, so to speak. Well, in a way I am, of Lloyd Ford, your ancestor, because he did provide a defining moment in my life. You go ahead and start those. I was a young graduate student. That is actually me. My children don't recognize that. But I was a young graduate student in American history at Vanderbilt. I'll just tell you, I'll just wave at you and tell you to advance the slides. That's Calhoun Hall, where I did all my work. And I had to write a paper. I had to write a seminar paper. And I was at that stage in my studies where the paper had to have some original research in it. And I had to agree upon a topic with my major professor. I know he's not of any interest to y'all. Click that next slide. I do this as a shout out to him because he had trouble at Vanderbilt. He got in departmental politics and got fired. He was long gone before I ever finished. But he's the guy who put me onto this case. He suggested that I look at a Tennessee Supreme Court case in which a judge, Nathan Green, had written. And we'll read through this. I think there are 3 slides that come up. He said in this case, a slave is not in the condition of a horse or an ox. He is made in the image of his creator. Next slide. He has mental capacities and an immortal principle in his nature that constitute him equal to his owner, but for the accidental position in which fortune has placed him. The laws under which he is held as a slave have not and cannot extinguish his high-born nature, nor deprive him of many rights which are inherent in man. He wrote that in the next slide, please. He wrote that in the case that becomes Ford v. Ford. But what David Bryan Davis said, this astonishing declaration was quoted by the time when I was in graduate school, was quoted in every major book. And there are about 6 or 8 slides you can just run through at the same time here. All the major books written on slavery at the time quoted this astonishing declaration. But nobody knew anything about the case itself. They just had this statement that Nathan Green had made. And so Kermit Hall said, why don't you take a look at it and see what you can find. I went down to the Tennessee Archives. That's the next slide. There's the main building, and this is the room. The next slide is the actual room in which I worked. And to my delight, I discovered that the Tennessee Archives have an incredibly rich holding of Tennessee Supreme Court material. Basically everything that ever was written about this, that went before the Tennessee Supreme Court, they still got it. And among those was the transcript for Ford v. Ford. Some of you have seen it. I think I was probably the first person to see it after it had been put in the archives. These documents, if you're familiar with those kind of documents, it was well before the typewriter. It was written out in just beautiful script. I don't know how they managed to do that. And of course, it was sealed with a ribbon. That's one of the places where the term, I won't go there. But how they have to put things together before they had staples and paper clips and all those kind of things. Well, they put them together with ribbon. And so there's a red ribbon bound through this thing. But this document not only included what happened before the Supreme Court, but it had the record of everything that had happened in the case from the very beginning, including all the testimony of everybody who testified at the trial. Now, how they managed to do this, recording it by hand, I still don't know to this day. But it was a gold mine. It was a gold mine of information which allowed me to write a successful seminar paper, which I later revised, and next slide I think, turned into an article for the Tennessee Historical Quarterly in 1975, which won 2 awards. One for the best article for that year, and then tongue-in-cheek for the article with the longest title ever been published in a quarterly. But Ford v. Ford had led me to the enormous repository of legal material that was the foundation for my dissertation. Go ahead and click on that. I would expand that to cover the whole state of Tennessee and to cover a wider range of issues. And so the dissertation was entitled "The Treatment of Slaves and Free Blacks in the State and Local Courts of Tennessee." It was selected as you can go to the next one, a distinguished dissertation in American Legal and Constitutional History by the Garland Publishing Company, which gave me a chance to revise it and improve it into a book called "What Saith the Law." And there's a picture of that it's now remaindered, and the libraries are discarding it. So my wife bought me a copy a few years ago of where the libraries had gotten rid of it. But by the time this was published, I had ended up I had started a career in junior college or community college administration, and that ended my career as a scholar. You can't be an administrator and a scholar at the same time. It takes entirely 2 different parts of your brain. But Ford v. Ford was the foundation of it all. The case itself evolved from circumstances that are rich in human interest. And go ahead and click the next one because it'll show Circle Washington County, I think. And I have long thought this worthy of stage and screen. It's a very dramatic set of circumstances. Lloyd Ford, as Jason's already pointed out, owned a 112-acre farm in Washington County, Tennessee. That's where we are now. The Buffalo Ridge District. I heard somebody made a mention to Buffalo Ridge a little earlier. The 1840 census, go to the next 2 slides. Well, this is just going to be a close-up of that. That's where we are there. And I'm going to mention Greene County and Johnson County in a minute. All right, the 1840 census, which should be the next couple of slides, has him listed as 83 years old. He is the head of the household. He's accompanied by 10 slaves in 1840, 3 adult males, 2 adult females, and 5 children. And there is and I'm not sure it shows on this slide, go to the next one. There is an older man living there, and if anybody has any idea who that is, I would love to know. There was an older white man who he was in the category of 50 to 60 years old. He was living there on that farm in 1840. Now
that was his son Louis III, I believe.
Was it? Is that the one that threatened to kill him because he
he and his wife had separated, and I think
he was still living there. He was not living there when Lloyd Ford died. All right, Ford's wife died before he did, so when the circumstances that are involved in the case began to develop, he was said to be living alone, except for his slaves, 3 men. I think I mentioned them. Let's see if it's on the next slide. Yeah, the 3 men, John, Ned, and Lark, Peg and her 6 children, and Rhoda and her 3 children. These were the only white children listed in the transcript of the case. I understand there were others, but these were the white children that were listed as being involved in the case. Peg and Rhoda had husbands on nearby farms. And their children lived then on the Ford farm. According to the testimony in the case, by 1842 or 1843, Peg had 6 children and Rhoda had 3. So there were a total of 14 slaves on the Ford place. Now, this was a substantial holding, okay, and both in land and slaves, especially for the area in which the Fords lived. Go to the next slide, please, Tennessee, those of you who are not from Tennessee, Tennessee historically has been divided into what's called 3 grand divisions. There's East Tennessee, Middle Tennessee, and West Tennessee. They are different. They are very different. East Tennessee, we're in now, is hilly. It has a long history of anti-slavery activity. It ended in the 1830s because of the Nat Turner insurrection in Virginia. But it's an area of small land holdings, hilly territory. Middle Tennessee is a blend, but by the time you get over into West Tennessee, you're into the plantation area. You're into big plantations and large slave holdings. Only 10% of Tennessee slaves lived in East Tennessee. So that gives you an idea. On the other hand, East Tennessee had 45% of the free black population. And as both Jason and I mentioned, there was a background of anti-slavery sentiment in East Tennessee. Although that shouldn't be overplayed, because Tennessee did secede from the Union and very much fought on the side of the South in the Civil War. And the anti-slavery activity pretty much died out in the mid-1830s. Okay, next slide. All right, this will give you place Lloyd Ford Holdings in perspective. In Johnson County, which was right nearby, only 13.4% of the people, this is, by the way, this was from a work done by a guy named Chase C. Mooney, who did a great deal of work on Tennessee, in the censuses and that kind of thing. But you can see in these nearby counties, very few people owned slaves. So the fact that Lloyd Ford owned slaves at all put him in a distinct minority of wealthy people. This is very different than what you see in West Tennessee, where the numbers would be over 60 and 70%. In East Tennessee in 1850, 90% of the slave owners, that's okay. That shows you the slave ownership in West Tennessee to give you a comparison between East and West Tennessee. All right, go to the next one. Go ahead and put them both up. In East Tennessee, 90% of the slaveholders owned fewer than 10% slaves. So Lloyd Ford's got 14. And that puts him in the upper, the 10% of the people who owned slaves in East Tennessee. This was, like I said, this was a substantial holding. In East Tennessee, most slaveholders operated farms of less than 100 acres. And he's operating a farm of 112 acres. So when you consider the case, there was a lot at stake here in this particular legal battle. All right, the Ford slaves were described routinely in the court testimony as good and industrious citizens, good, honest, and industrious citizens. It is clear that Lloyd Ford trusted his slaves. He allowed them considerable freedom of movement. He depended upon them, certainly by the time he was in his 80s, he depended upon them to manage his farm. And on more than one occasion, he remarked, all of this is according to the testimony in the trial. He remarked that he considered his slaves his black children, even comparing them to his other offspring, saying that his slaves had been better to him than his white children. That was something that he said more than once, at least according to the testimony. And Lloyd Ford, by the time he was getting nearing death, wanted to ensure that when he died, his blacks should not serve his white children. And I'm using that as that's a quotation from the testimony. Knowing that he was nearing the end of his life, he decided that upon his death, John, Ned, Lark, Peg, Rhoda, and their children would be given their freedom and would be given the farm on which they lived. And he would provide for that in his will. So this is a case of what's called post-mortem emancipation. Now, it is unknown whether Lloyd Ford was actually the natural, biological, genetic father of these children. Or whether or not he was just speaking paternalistically. It is interesting that in the court proceedings themselves, there was a dispute over whether or not, or about the admission of testimony showing that Lloyd Ford was the father of the natural children. The dispute was over the testimony. When the Supreme Court ruled on the matter, it declared that it was proper to introduce evidence that Lloyd Ford was the natural father of these children because it tended to establish his sanity. One of the issues in the case was whether or not old Lloyd Ford was sane when he made his will, and the testimony indicating that he was that these black children were in fact his children was, the Supreme Court considered, proof of his sanity. I will say this, and this is a digression here. I teach sociology, among other things, now, and I teach a course on the family, and when we have to end up defining what the family is, we finally get down to the root definition of a family. A family is who you say it is. If you have people that say they're family, they are family. Because the definition of a social group, at the very least, is people who interact with each other and identify with each other. It's the two I's that are critical to passing my test. So if you identify as a family and you interact with each other, you're a family, period. So the issue of genetics, I would say doesn't matter. Well, anyhow, Lloyd Ford wanted to free his slaves. He couldn't legally do it the way he wanted to, because in 1840, Tennessee law provided that slaves who were freed by will could get that freedom only if they agreed to leave the state. They had to immediately remove once they got their freedom. Now, Ford apparently believed otherwise. He believed that, as testimony put it, the laws were so fixed that if he gave his slaves land to live on, he could free them. Now, let me digress here again. Prior to 1831 and the Nat Turner insurrection in Virginia, which scared the entire white South to death, prior to 1831, all a freed slave in Tennessee had to do was to prove they wouldn't be indigent. They wouldn't become a burden on the state. They wouldn't become welfare. And if a slave prior to 1831, a freed slave could demonstrate that, they're fine. They could stay in the state. That changed with the Nat Turner insurrection. After 1831 and until 1842, a slave could be freed only if they agreed to leave the state. Now, that law was changed in 1842. Tennessee essentially went back to their old agreement that if a slave was born in Tennessee or who had become a resident in Tennessee prior to 1836, a slave could be freed if he or she could demonstrate they wouldn't become indigent. But in 1840, the old law was still in effect. So Lloyd Ford really couldn't do what he wanted to do. But my guess is this law, the discussion about this law was already kind of in the air, and Lloyd Ford had heard about it, because by the time he died, he could do it. What he did was legal. Now, let me go back to the story. On March 1st, 1840, Lloyd Ford asked a neighbor, Robert G. Hale, to prepare a will for him, a will which would free his slaves and leave them to farm. Hale prepared the will. His wife, Sarah, and daughter, Jane, witnessed the will. Neither Ford nor Sarah or Jane could read or write. They had to witness it by their ex, which becomes an issue in the trial. The Supreme Court sweeps it away in a hurry because very few people could read and write. But they signed big X's on the document. Ford asked Hale to keep the will. He did this because he was afraid his white sons would steal it away from him. Hale agreed to keep the document, and Ms. Hale put it in a chest. About 2 years later, in the fall of 1842, so the 2 years had passed between the time the will was written and this set of events, the will becomes the focus of an intriguing series of events. Lloyd Ford apparently was a pretty hard drinker. He goes to the Ford house very drunk, not the Ford house, I'm sorry, Robert Hale's house, very drunk. He visits again, appearing distracted. These are not my words, these come from the transcript. Appearing distracted, delirious, and distressed. And he asked Hale, he told Hale, and this is where this quote that Jason mentioned, he asked Hale if he still had the will, because he said Lloyd Ford Jr., his eldest son and namesake, had threatened to kill him if he didn't destroy the will. Now, Hale didn't want to do that. Hale didn't want to give him the will, but Ford insisted. And so Hale finally told his wife to go get the will. Well, she didn't get it. She went in and brought what she called an old school article. Now remember, Lloyd Ford can't read, okay? She handed it to Lloyd Ford. He took it, looked at it, shook his head, and sort of laughed. That's the quote from the testimony. And he said, "Bob, put it in the fire and burn it. Maybe it will satisfy them." Okay, it seems clear that Ford knew that Hale had not incinerated his will, because a few days later, apparently sober, he returns and asked Miss Hale if she still had the will. She told him she did, and he told her to do with it what he said when he died. It also appears that Lloyd Ford's white sons knew that the will had survived, because they tried to purchase the document from Sarah Hale, and she refused to give it to them. And in the interest of safety, and I've always liked this line from her, she put the will over my bed underneath the planks that jutted over in the corner of the house. So that's where the will sits until Lloyd Ford dies, I think November 1843. So he dies in 1843. On December the 4th, 1843, his black children go to court. Now, they couldn't do this on their own, even in Tennessee. And by the way, I should point out that this set of circumstances almost could only have occurred in East Tennessee, in East Tennessee. You might have had something similar in Kentucky, but location here really makes a big difference. But anyhow, even in Tennessee, a slave had no standing in court. And a slave had to go to court through what was known in legal terms as their next friend. And the next friend in this case was a person that I know very little about. Jason says he's tried to, her name was Phoebe Stewart, a lady, and Jason has done some research that suggests she was a cousin to the lead attorney in the case.
His wife.
Do what?
To the wife of the lead attorney.
To his wife, the lead attorney in the case. It may have been a legal fiction of some sort, and you had to have it, because there is one case in Tennessee where the slaves weren't able to get an ex-friend, and the court wouldn't have a hearing for them at all. So, John Ford et al. And others, by their next friend, Phoebe Stewart, go to court in Washington County Court. Now, in all probability, there was an attorney directing all of this, and let me digress here and talk about the attorneys in the case. It appears that T.A.R. Nelson led the cause of Lloyd Ford's slaves. He was a very prominent politician here in East Tennessee. He was one of the founders of the Whig Party. His offices were located down here in Jonesboro. And he appears to have been involved in this from the beginning. Another attorney involved in the case was Robert J. McKinney. And there is a letter from McKinney to Nelson. This didn't find its way into my article because of stuff I found working later on the dissertation. There's a letter in Nelson's files from McKinney in which McKinney, whose offices were located in Greenville, responds to a request from Nelson asking him, and these are McKinney's words, and he's clearly trying to be humorous here. He's asking him to let myself down to the dry, dull investigation of the rights of Ford's Negroes to freedom. So Arnold had apparently asked McKinney to check into the situation. Then he says, in a more serious vein, he reported to Nelson that he was gratified to learn that the Negroes in all probability could make out a case entitling them to their freedom. McKinney went on to say that Ford's white heirs had approached him, proposing liberal terms if he would represent them. McKinney said he had declined, not knowing what you thought of, writing Nelson, not knowing what you thought of the case on a more particular examination. McKinney continued, but as you have made an arrangement for me, I cheerfully acquiesce in it, as I prefer appearing for the Negroes, though for a less and more precarious compensation. So you've got two pretty powerful lawyers here. McKinney and Arnold, T.A.R. Nelson rather, we know represented them in the Supreme Court case, and McKinney actually, the year after the first Ford trial in the Supreme Court case, is elected to the Supreme Court himself in 1847. So this is some pretty high-powered attorneys. There is other correspondence in the Nelson papers indicating that there was a third lawyer involved, a guy named Thomas D. Arnold, and I wasn't able to find a picture of him. And this correspondence concerns the notes that John, Ned, and Lark had signed promising to pay him for attending to the case of John Ford and others in the Circuit Court and in the Supreme Court. Arnold is disputing the notes for two reasons. He said, first of all, nobody ever said anything about me going to the Supreme Court. The notes were, actually there were three reasons he disputed. The notes, each individual had signed a note, and he said they all were supposed to be signing one note, and the amount was supposed to be $250 rather than $200. But apparently he was involved in the case at the circuit level, which we'll get to in a minute. Now, how were the slaves going to pay for this? Well, they were hired out, and that was a term that was fairly common. They were hired out by the courts, and then the income that was derived from them working and for other people would pay the lawyers. I mean, the lawyers are no different then than they are now. Okay, they're going to get their money, that was where they did it. Nelson commented, unless I am greatly mistaken in the character of the boys, and I apologize for the anachronistic use of these terms, but unless I am greatly mistaken in the character of the boys, I have no doubt whatever they will pay us, though we may have to wait some time for our money. Now, William Henry Sneed, a Knoxville attorney and a former law partner of McKinney, argued the case for Ford's white heirs before the Supreme Court, and I don't know anything else about their attorneys. It is sort of interesting that McKinney and T.A.R. Nelson and Arnold all fought against secession when it was being proposed in Tennessee, and Sneed, on the other hand, was an ardent secessionist. So I don't know if that means anything. It's just kind of an interesting coincidence. All right, let's go back to the Washington County Court. John Ford and others, that's the way the official title, told the Washington County Court that they had been informed that their former master had freed them in his last will and testament, and that great efforts had been employed to suppress and destroy that will, but that the will still existed, and that it was in the hands of either Robert or Sarah Hale. They asked the court to order the Hales to produce the will and to attest to its validity. It would have been really easy for the county court here just to said no, and it would have ended the whole thing. I think one of the really interesting things about this is how I don't want to say well, but how judiciously the black plaintiffs were treated all the way through this. And I will say that in my broader study that this was not unusual for Tennessee at all. In civil cases and in criminal cases, if a slave could get into the regular court system, their treatment seemed to have been fairly good. All right, the county court agreed. They asked the Hales to come, and the Hales complied with the court's instructions. When the former slaves attempted to get the will probated, the executors of the will, and why Lloyd Ford didn't change the executors. The executors were still James and Grant Ford, his white sons, and they refused to do their job as an executorship. They refused to act. And then they contested the will. And so that makes this a case of a contested will. There was actually another way this could have been tried, but it was in Chancery Court, but it wasn't. So the county court, Washington County Court, certifies the fact that there was a will a contested will. This is what the legal proceedings said they had to do, and they sent the matter to the Washington County Circuit Court for a jury trial. The White heirs who contested the will had to post a bond of $500 to cover the court costs should they lose the contest. And that's where Ford v. Ford, the case itself, is born. The case was put on the Washington County Circuit docket in December 1843. It took a couple of years before it came to trial, and I found nothing in this other than just normal routine procedure that delays it. It came to trial in October 1845. The plaintiffs, the White heirs, did question Lloyd Ford's sanity, but the primary argument was that the will was a forgery. And so a great number of witnesses were called to testify on this matter, both for and against the Hales, Robert and Sarah Hale. It also appears that the attorneys for the slaves called a large number of rebuttal witnesses, undercutting the veracity of those who testified that the Hales were not truthful. And this appears to have worked because the jury in November 1845 upheld the will, giving the slaves their freedom. There's a chronology here. You can follow it now, I think. Giving the Ford slaves their freedom and the farm. The judge denied a petition for a new trial, and the White heirs appealed on a writ of error to the Supreme Court. There may be a slide about these. The Tennessee Supreme Court, which heard this case, was a three-man court: Nathan Green, William B. Reese, William B. Turley, a group which a later court historian called the legendary triumvirate, who presided over the golden era of Tennessee jurisprudence. The attorneys for Ford and the White heirs cited a number of errors. They argued that you couldn't sign a will by making a mark. That didn't fly. Nobody would do that in 1840. Most legal documents, many legal documents were signed that way. They said the circuit judge had improperly defined a legally sound mind, that the circuit judge had improperly allowed evidence tending to establish the slaves and Lloyd Ford's natural offspring. We already discussed that. The judge had improperly instructed the jury regarding rules of evidence determining the credibility of a witness, and that slaves have no rights which would permit them to bring this type of action in the first place. It was against this argument that Nathan Green made his astonishing declaration that made the Ford case so important, so noteworthy, when he says, a slave is not in the condition of a horse and an ox. They've got rights, and one of them is the right to come to court and to establish their freedom. And so it was against this argument against the White heirs' argument that he made that declaration. What has not got much attention is the fact that the Supreme Court actually ruled against the Ford slaves. They did find error in the Supreme Court judge's instructions to the circuit court jury regarding the requirements for testimony impeaching the character of a witness, and that the judge had wrongly instructed the jury with respect to the will burning incident. The circuit judge had instructed the jury that since the actual will had not been burned, it had not been revoked. The Supreme Court said it was Lloyd Ford's intention which was paramount. It didn't matter whether the will was burned or not. It was what Lloyd Ford intended. And the Supreme Court said that is something the jury should have decided. And so they sent the case back. It was reversed and sent back to the circuit court for a rehearing. And it would be 4 more years before we get to a final decision. And again, I can't find anything going on there other than the fact that the courts just acted slowly on everything. During this time, though, on petition of the slaves, the penalty bond in the case for the white heirs was raised to $2,500. That's a lot of money. It was a circumstance that later caused them to pursue the cause, and I keep in form of papyrus, that may be up there somewhere, but as in the form of a pauper, meaning the Ford white heirs came to the court and said, we can't pay for this anymore. But there was a proceeding that would allow them to continue the case. They also got a change of venue. The change of venue was because they could not, again quoting the case, they could not get justice in Washington County. And without objection, the case was transferred to Johnson County Circuit Court in Taylor. That court heard it in 1850. Once again, this is a jury trial. They once again upheld the will as valid. It goes back to the Supreme Court for a second time, and the Supreme Court upholds the verdict this time. And the next year, the tax assessor of Washington County enters the 112-acre farm of Lloyd Ford Sr. in the name of John Ford and others. So they get their freedom and they get the property. Now, according to one student of Ford family history, this decision and court cost, lawyer cost, travel cost, eventually led the white heirs of Lloyd Ford from riches to rags. According to his account, this is a reading from this genealogist's account. He said they left Washington County by wagon train in the middle of the night with only their possessions which they could carry in their wagons. They left their land and other possessions for their debtors to fight over. They crossed the Cumberland River and on to Monroe County where they started over. He says, my grandfather Sam Ford told of remembering dragging his feet in the water as they crossed the Cumberland. The Fords in Kentucky did not give up. There is a letter in the T.A.R. Nelson files dated April the 15th, 1855, from a Leslie Black, in which Black explains that there is a large family of Fords settled in this county who migrated here from your section of Tennessee. Some of them tell that they are entitled to a large number of Negroes who are now regarded as free. These Fords in Kentucky, Black writes, claim to be in possession of testimony not then known of, amply sufficient to enslave the Negroes, and that the will that freed them was a fraud. And Black wanted to know if Nelson, from Nelson whether the tenure by which the Negroes now exercise their freedom is such that they are beyond the reach of these Fords, and whether Nelson could be employed to persecute a suit further. I have no idea how Nelson responded. If he did respond at all, it would be in somebody else's papers. But that you are all here today seems to be ample evidence that nothing came of that inquiry. I want to once again thank you for inviting me and to tell you how unique this gathering is in this era in these days of ours when division seems to be the dominant theme in social and political life. The fact that you guys have come together and is more than noteworthy. This ought to be attracting a lot of our people. And I thank you for all you do.